Professor, for the introduction. At the beginning, I'd like to express my congratulations and my gratitude. I'm very happy, I'm very grateful for being here, for being participate in this conference, in this event. The topic of my presentation is the impact of family foundations on Polish inheritance law. I divided my presentation into 5 main bullet points. At the beginning, I'd like to tell you briefly about historical overview and the regulation source of family foundation in our legal system. After that, I'd like to tell you why our legislative decided to implement this new legal entity into our legal systems, what challenges in company successions are and were and still are in Poland. The main purpose of family foundation, using a screenshot from the Lion King movie, some highlights about family foundation, and at the end I'd like to focus on my meritum of my presentation, which is the impact on inheritance law. So we have very short history of family foundation in Polish legal system. The family foundation is a relatively new entity in the Polish legal system. It was introduced into the Polish legal system on the basis of the Act of 26 January 2023 on family foundation, and it's constantly gaining in popularity. At this moment, we have registered around 1,000 family foundation. So why our legislative decided to establish a new legal entity? When we are looking into the justification of the legal act, we can find a lot of market researches about it. Market research has shown that nearly 830,000 companies in Poland are family businesses. These companies generate revenues of a total value of 322 billion per year. Their contribution in Polish GDP is about 80% year after year. The Family Business Institute has prepared data showing that approximately 57% of family businesses are planning a succession within the next few years, but only about 8% of these legal successors declaring a desire to run the business established by their parents. About 50% of the companies planning succession have to look successors to run the business outside the closest family. So the biggest challenges in business succession in Poland is therefore for entrepreneurs to have legal successors who will be able and willing to continue to run the business, or at least exercise ownership functions in it, entrusting management to a professional board. This condition is not always possible to fulfill. Difficulties in succession planning also often arise from the quantity of potential successors. In large families, there is most often a division of successors into those who will take over the family business and those who will receive such kind of compensation, for example, in the form of property or in the form of cash. Efficient communication and decision-making mechanism within the family can also be a problem. In the absence of successor or disagreement between family members, business owners often decide to sell the businesses. This leads to the loss of the family character of the company. There is a growing trend of foreigners buying up businesses, interested not only in taking over a company with a well-established organizational structure, but more importantly, a reputation on the market. In the past state of law, the owners of family businesses have limited options for the transfer of their businesses. They can avail themselves of the solutions contained in the provision of Polish Civil Code and the Polish Commercial company's code. It was common for business owners to decide to donate or bequeath their business to a person or persons of their choice. However, this only ensures succession in the second generation. By contrast, they have no influence on the future of the business and the wealth accumulated through it. In the case of shares in partnership, there is another important aspect of the restrictions on the freedom to dispose of the partnership share. A change of partner is only permitted if the partnership agreement provides for this and the partners agree to the new partner. Succession can therefore be blocked by the other partners. In the case of limited liability company, the partners may agree that the entry into the company of the heir of deceased partner is either limited or excluded. In addition, the possibility to divide shares between the heirs may be limited or excluded. Restrictions similar to those in limited liability companies do not exist in joint stock companies. Even in the case of a joint stock company, when its shares are inherited by more than one heir, they become a subject common to the heirs. Ownership of shares by several persons is fractional in nature and subject to the relevant provision on joint ownership in fractional parts. A different regulation of the inheritance of shares is only possible by drawing up a will containing relevant disposition in accordance with the will of the shareholder. However, this does not ensure the performance of the business itself. The successors in the title have an unlimited right to dispose of the inherited goods. So, the analysis of the above solutions leads us to the conclusion that Polish law mainly focuses on the protection of individual interest of heirs among to inheritance, family law, or shareholders of the companies. Such solutions do not guarantee the stability of running a business according to the will of the company's founder. Thus, we did not have, until the establishment of family foundation, sufficient instruments in the Polish legal system to ensure protection against the division, the fragmentation of property created in connection with business activity after succession, either during the owner's lifetime or after his or her death. This problem also applies to cases where the family or other legal successors of the owner wish to continue the entrepreneurial activity of the doyen. The lack of solution in this area is particularly noticeable among those who would like to take care of the future of the accumulated wealth in a perspective of more than 2 generations. Moving forward to the main aim of the family foundation, I'd like to tell you that the purpose of this legal entity is very good shown by a proverb from Lancaster from 19th century that goes, "There's no but 3 generations between a clock and clock." So we can understand this proverb that father builds, son maintains, and grandson ruins. The family foundation in its conception is intended to create a mechanism for integrating wealth, capital accumulation, and managing it in a way that preserves activity in the economic sphere and provides livelihoods for future generations. In other words, the family foundation is an institution for the accumulation of family wealth, which allows capital to be retained in the country for many generations and to increase the potential for domestic investments. The family foundation is intended to minimize the risk of a failed succession and guarantee the continuation of the business. The transfer of assets, including the family businesses, to a family foundation is intended to protect them from distribution, to enable them to be multiplied and therefore to benefit from them, which can be used to cover the living expenses of those designated by the founder. Indeed, it is crucial to ensure that continuity of the private enterprise, in particular for the purpose of securing the family. In doing so, it is essential that the family foundation is able to meet the needs of the beneficiaries who will in principle be a family members. In this moment I'd like to present you the most important information about the family foundation in Poland. So I present you the highlights of this legal act. As it follows from the law, a family foundation is a legal entity created by the founder to accumulate property, manage this property in the interest of beneficiaries, and fulfill benefits from the beneficiaries. The purpose of the foundation is determined by the founder. The founder of family foundation may be only an individual with a full legal capacity. The benefits made out to beneficiaries are assets including cash, property, or rights, either transferred to the beneficiary or even to the beneficiary or given to the beneficiary for use by the family foundation. Beneficiaries may be natural persons and non-governmental organizations carrying out public benefit activities, which, according to their status, may receive benefits from the family foundation. It is worth mentioning that the beneficiary of a family foundation may also be a founder himself. Importantly, a family foundation may carry out business activities, but only with the scope defined by the law. Pursuant to Article number 5 of the Family Foundation Act, a family foundation may carry out business activities within the scope of, for example, disposal of property, renting property, accession and participation in commercial companies, investment funds, production of non-industrially processed plant and animal products, or, for example, forest management. A family foundation can be established through a declaration by the founder in either a deed of incorporation or in the will. Irrespective of the manner in which the foundation is established, both the foundation deed and the will must be drawn up in the form of notarial deed on pain of invalidity. In a family foundation, if a family foundation is to be established, the founder must contribute property to cover its founding fund, which is at least 100,000 Polish zloty. So, going to the meritum of my presentation, I'd like to draw your attention how family foundation impacts of our inheritance law in Poland. The introduction of family foundation into the Polish legal system has led to important changes in inheritance law. The realization of the objective of establishing family foundations entailed the necessity to introduce relevant changes in the inheritance law, which covered inter alia the institution of a reserved share, the rules concerning its amount. So what changes have taken place in inheritance law? Firstly, the possibility for family foundations to inherit the inheritance is provided for. Pursuant to Article 927, paragraph 3 of the Polish Civil Code, a family foundation established by the testator in his or her will may be a heir if it is entered in the register within 2 years of the promulgation of the will. This provision, therefore, gives the foundation the possibility to inherit the inheritance even if it was not yet operational before the date of the will's promulgation. In doing so, the foundation can acquire an inheritance any person, not only from the founder. The catalogue of sources of satisfaction of the legitimate portion of the estate has also been supplemented by a benefit from a family foundation and property received in connection with the dissolution of family foundation. Due to the fact of the establishment of family foundations, the catalogue of persons with passive legal standing in cases for payment of the legitimate portion also had to change. Previously, a claim for payment of a legitimate portion share could be filed first against the heirs of the decedent, then against person to whom legacies were made, and only in the last instance against beneficiaries. Currently, as a result of the addition of paragraph 5, 4, 6, and 7 to Article 1000 of the Polish Civil Code, the legislator has introduced the possibility of claiming a sum of money needed to supplement the legitimate portion amount, also from a family foundation, whose founding fund was added to the inheritance, as well as from a person who received property in connection with the dissolution of the family foundation added to the inheritance. These entities, however, are liable only to the extent of the enrichment obtained on this account. However, key modifications appeared in the case of the procedure of determining the amount of the legitimate share due to the beneficiary, and more precisely the rule concerning the mathematical regulars, the calculation of the so-called reserved share. In variability, if the beneficiary is a minor or permanently incapacitated, the reserved amount is the 2/3 of the value of the share of the estate, which would fall to the beneficiary in case of statutory inheritance, and in other cases, half of this share. The resulting fraction should be multiplied by the above-mentioned substitute of reserved share, which consists of the pure value of the inheritance, the difference between the value of the assets forming part of the inheritance, and the value of the inheritance debts. Previously, this value was determined regarding the value of ordinary bequests and instructions, but taking into account the value of the gift and legacies to be added. Currently, however, in addition to the obligation to include legacies and countable donations in the inheritance, the legislator has introduced the necessity to add the founder's inheritance according to the principles set forth in Article 994 with index number 1 to 995 of the Polish Civil Code. Also, the founding fund of the family foundation contributed by the testator and property in connection with the dissolution of the family foundation. There is, however, one exception to the above rule, and it concerns the situation where the foundation fund was contributed to the family foundation earlier than 10 years before the testator's, the fundator's death, in which case the amount will be not added to the inheritance. The exceptions therefore only applies to family foundation established during the founder's lifetime and which have been in operation for at least 10 years prior to the founder's death, in order to prevent fragmentation of foundation's assets. However, the situation will be different in the case of a foundation established in a will. In such a situation, all the fundator's assets will form part of the founder's estate, which it turns open the way for the payment of a legitimate portion from a family foundation, in principle in perpetuity. As a result of the above, this type of solution should be only restored to an emergency. In order to avoid fragmentation of the estate, the succession should be planned and implemented in the form of family foundation well in advance. The new provisions introduced a possibility hitherto unknown in the inheritance law to spread the payment of the legitimate portion of the estate into 5-year installments, and in exceptional situation even up to 10 years, and to postpone its payment. Moreover, in the 4th book of the Civil Code, there finally appeared a provision allowing to reduce the amount of the legitimate portion in exceptional situations, which so far has only been invoked on the basis of provision Article number 5 of the Civil Code on abuse of subjective right. However, the possibility to make use of this solution depends on the personal and financial situation of the person entitled to be reserved portion and the person obtained to satisfy the reserved portion claim. This may complicate matters somewhat for potential heirs, particularly if the inheritance has resulted in an increase in wealth and enrichment on the part of the heir. This solution may prove helpful for heirs to so-called empty heirs who received a donation from the testator during his lifetime, which will be counted against the reserved portion to which they entitled. So, brief conclusions. Assessing the effectiveness of a family foundation has its advantages and disadvantages, but it's still a new entity. Advantages include the ability to effectively manage family assets, allowing them to be protected and multiplied for the benefit of future generations. A family foundation also enables better succession planning, ensuring business continuity and minimizing the risk of family disputes. On the other hand, setting up a family foundation comes with some disadvantages. The process is complex and costly, which can be a barrier for less wealthy families. In addition, the foundation has to comply with numerous legal and regulatory requirements, which generates additional administrative costs and obligations. Finally, the limited flexibility in management of foundation assets can be perceived as an impediment to adequating to changing market conditions. Regardless of the above, however, the introduction of the family foundations into the Polish legal system should be assessed as a positive and as a good step, as a step in the right direction towards enabling family business successful planning, because family constitution, about Kinga will tell you, in Poland are not popular. So from my side, thank you very much for your patience, for your attention.